Dear colleagues, we will start our workshop now with the first topic, mediation trends and practice in various IP areas, where we will get to know more about the global trends in IP mediations and assessing the suitability of IP disputes for mediations. We will have a Q&A session right after this first topic, so you can share with us your questions either during or right after the presentation. For the first topic, I would like to invite Ms. Alexandra Crawcour, legal assistant and accredited mediators, and Mr. Goran Marjanovic, accredited mediators from the Court of Appeal, EUIPO, to help us with the first topic. Ms. Alexandra Crawcour is currently the legal assistant and accredited mediators of the Court of Appeals in EUIPO. As a legal assistant since 2010, Alexandra is responsible for drafting decisions on appeals regarding EU trademark and designs, and representing EUIPO as agent before the EU General Court in Luxembourg. Alexandra has been appointed a mediator, co-mediator in several cases at the EUIPO since 2012. She has also engaged in continued mediation training, participating and organizing mock mediations, internal workshops, and IP mediation conferences. Mr. Goran Marjanovic, with over 10 years of experience at the EUIPO, has handled legal matters, litigations, international cooperation, and institutional relations. Recently, Goran joined the ADR service at the EUIPO Court of Appeal, where he has been working on the creation of a mediation center at the EUIPO. Previously employed as a lawyer in an international IP law firm and in legal affairs at the European Commission, Goran is specialized in EU and international IP law, as well as in institutional relations and cooperation. Goran has also attained accreditation as a mediator from the leading international ADR service providing organization. Alexandra and Goran, we thank you very much for joining us today. Now I would like to invite Goran to start with the first presentation. Goran, the floor is yours now.
Good afternoon to all of you. We can get going with topic one, which has been entitled Mediation Trends and Practices in Various IP Areas, that I will be going through with myself and Alexandra. This slide, I think, just shows a bit of let's say, timeline for what's going to happen during this part of the session. And then I will begin with my part. Now, I'm going to do something I think probably most presenters shouldn't do, which is perhaps admit that maybe the title could have been more appropriately articulated. I was supposed to be talking about global trends in IP mediation. However, I believe that a more appropriate title would be that IP mediation is a global trend. So I think we're going to talk more about how IP and why IP mediation has become a trend rather than any specific trends in global IP mediation, because I believe that the main trend is that it's increasing. But mediation is mediation. So with that, I think we'll start with a brief introduction in mediation. Overall, I'm going to have to be very brief about this. And the main reason is that some of you may have already attended previous sessions in which you went further into depth. And also it will be covered in greater detail today, so I'm not going to take too much time, but just for setting the scene, I think we can briefly have a look at this definition of mediation that you now have up on your screen. So it's a process in which parties to a dispute are guided by a mediator and they try to reach an amicable settlement for their conflict. Now, generally, they try to identify common grounds that goes beyond just what their positions in the conflict are. And this includes their business interests and maybe even personal interests in some cases. And this settles the dispute because it can open certain potential for finding an amicable agreement. So that's when it works properly. Obviously, it's not always the case, but as Carolina said, the success rate has been pretty high, so we remain very positive and optimistic about it, especially because a lot of the parties to commercial types of disputes seem to be recently preferring to go the mediation route rather than the litigation route. So with that, we talked about the types of actors that are normally in a typical mediation situation. We say mediator or co-mediators. Again, I will not go into too much depth, but there needs to be one professional at least guiding the process, the mediator, but there can be co-mediators, and this is an interesting opportunity when it's a complex case, maybe where it requires both technical and legal knowledge, or it requires more than one language, but this will be discussed in greater detail later. Obviously, there are also the parties. In our case at the EUIPO, they are normally applicants for a trademark, or they're holders of a trademark right, and they're in a conflict. Normally it's companies, it can also be private individuals that have applied for or hold a trademark right. And then usually most of the time, and it's very helpful when they do, is that they come with legal representative to help them with the legal aspects and maybe even some of the business aspects. Now, normally, like with any process, there are different phases. So let's say it starts with a request for an ADR or for a mediation specifically. But before that, in our case, the parties are already engaged in a conflict. So normally they've already had a decision taken by our office at the first instance level, and they've filed an appeal to that decision. Once they're in the appeal proceedings, they have the option to request ADR, including mediation. And then provided that both of the parties agree to this, both of them wish to avail of mediation, we always accept. And then it's time for the parties to begin preparing for the mediation, which requires learning more about how the process works, making sure that they know their positions and arguments, but also being prepared to engage in discussion, to potentially make offers or listen to the other side and see where some common ground could be found. Now, this then culminates in the mediation day, is what we call it. Now, the mediation day will probably be described in further detail as well, but it's a series of meetings that are run by the mediator. Sometimes there are single sessions where he or she is speaking with only one of the parties. And sometimes there are joint sessions where the parties can state their positions to one another and also make offers with a view towards getting to an agreement. So the main principles of mediation that are also included in this slide are those of confidentiality, independence of the mediator, is that the mediator should not be partial, or cannot rather be partial to either of the two parties, must be fully independent and really treat both parties with the same amount of attention and respect without showing any favoring whatsoever. And confidentiality applies to both the process itself. The mediation process is fully confidential, and this is always indicated in the mediation agreement that's signed before the mediation, not to be mistaken with a settlement agreement. Before going into a mediation, both parties have to sign the mediation agreement as well as the mediator, and they basically agree to be fully confidential, not basically to not disclose externally any of the information or content that is discussed during the mediation itself, which the onus of this really is on the mediator. Even within the mediation, the mediator is not, when he or she comes out of a session with just one of the parties, the mediator is not even allowed to tell the other party what was discussed in the session unless the party allowed him or instructed him or her to do so. So that's a brief introduction, a very, very quick one on how mediation works, or at least is supposed to work. So I think now we can try and get in a bit into the global trends in IP mediation, provided that if that's still what we want to call it, but I would say that mediation is a global trend. Now, why would mediation be a global trend? I guess that's an interesting question to ask as well, particularly in the EUIPO's case, because as being the trademark register of the whole European Union, and we also accept applications from basically any country in the world, by nature, most of the conflicts that come up before the EUIPO are cross-border. They're international. And so for those parties to think about going to court to proceed with litigation, they have a number of issues about potentially even jurisdiction, depending on the issue, the costs, what kind of lawyers they might need. And a good part of this really could be resolved just by sitting down at a table with the other party and a mediator, and talking it through to see if there's potential for a solution. Now, this immediately becomes much more attractive than engaging in further time-consuming and costly litigation. So that's what I would say. As it says, it's a powerful tool to assist in changing perspectives. Well, that's particularly for us here in Europe. In Europe, we were really litigation-minded, and we tend to, our initial reaction is to go for a formal proceeding, for example, a court. Whereas my understanding, and this is something that I would be very happy also to hear about from the Asean colleagues, because based on recent reading and research, I've understood that in Asia, to what extent that can be said generally, please forgive me, but that there is a general cultural tendency to try to resolve disputes and conflicts without going to court. So I would be very interested in hearing more about that later on if we get into any discussions, which means with respect to ADR, culturally speaking, and maybe psychologically speaking, you're already more geared towards ADR. So like ADR in general, that's why I would say mediation is a global trend because of the nature and characteristics of international commercial disputes, and because of all of the different advantages that reaching a amicable settlement through a mediation or ADR process can provide. And my belief is that this will continue rising so that courts can focus on, let's say, more important things, and parties to a commercial dispute can try to resolve their issues with the help of a mediator. And if I stay more on the topic and go to the far box, stay on the topic of perhaps Asian culture, we also think that a massive development in ADR globally has been the UN Singapore Convention on Mediation, which, entered into force in September 2020. This is something that is still not fully up and running, at least is my view. There are 55 signatories and 8 ratifications, including, of course, Singapore. Now, the purpose of this convention was to provide a uniform and efficient framework for international settlement agreements resulting from mediation. It applies to international settlement agreements concluded by parties. So in order to resolve a dispute, so what it tries to do is basically for those that have signed and ratified those jurisdictions, basically agree to enforce and recognize agreements that have been reached by parties in a commercial dispute through mediation. It's intended to give global businesses more assurance that if they do opt, if once they're in a dispute, if they do opt for the mediation route to settle the dispute, that they will be able to enforce and have recognized the agreement that they've reached through this. So on that point, as I said, of the Asian member states, my understanding is only Singapore has ratified. This would be another thing that I would be interested in hearing from you, if you know why maybe some of the other countries in ASEAN have not ratified. So if you know anything about that, it would be a nice part of the discussion as well. Also, I do see that there have been some signatories from the Asian countries. I believe I saw Malaysia and Brunei and Philippines, and I'm not sure if there are any others. So the EU and the member states have not signed even yet the convention, but that's I will talk a bit more about that later. What I think is also important to briefly discuss is something that maybe further contributes to the popularity and growth in this trend in IP mediation and ADR, is the potential to use hybrid processes. And hybrid processes can also each have their own advantages that go beyond just a single process. You have MedArb, where the parties agree to start with a mediation. Then they feel each other out. They feel the arguments, how strong they are in position, how much they're willing to give. And if the mediation should fail, they proceed to an arbitration. Why would they proceed to an arbitration? Because they would actually have a decision taken. There would be an arbitral award, and that would conclude their conflict, albeit without an amicable settlement, but rather with a decision taken. There's the other approach where you could start a bit harder by first engaging in arbitration, feeling out one another's arguments again, and seeing whether within this exploratory part, there is enough room to actually resolve it through mediation, that is, reach an amicable settlement, rather than proceeding with the arbitral award. And finally, one other potential is for mediation expert determination, med-ed. Now, what happens is that in certain mediation cases, the parties obviously have an interest in settling the dispute amicably. That's why they've agreed to go for mediation, but they get stuck on a certain technical point of disagreement. And this kind of tends to stall and prevent progress in the mediation itself. So the possibility of going to expert determination within the mediation is that the parties could choose to appoint an expert in whatever the field or sector that they have this technical disagreement on, to give a binding or non-binding opinion on the matter. And this can help break the impasse in the mediation so that they can go forward. So I won't go too much further on that, because I think also the different forms will be discussed, but this is more to say that the potential for having hybrid processes has likely also let's say, increase the global popularity of ADR, which would therefore include mediation and also in the field of IP. So as I mentioned before, in the EU, no, we are not yet party to the Singapore Convention. If you ask me, yes, I think I'd like to be, we could or should be, but this is obviously a democratic political decision that's yet to be taken. So we're not there, but I hope we will be. Though we do have mechanisms that bring us at least within the 27 member states of the EU, close to, or maybe in some situations beyond even what the Singapore Convention is trying to do. In the top left box, we talk about the directive on mediation, but before I get into that, I think it's useful for the ASEAN colleagues, in case they don't know, just to briefly explain what a directive is. Basically, the 27 EU member states, they each have their individual legal systems and jurisdictions, but they also apply EU law. Now, the two main instruments for EU legislation, aside from the general overarching EU treaties, are regulations and directives. Regulations are prepared by the EU institutions, and they apply directly to all of the 27 member states. Whereas directives are somewhat more flexible. They allow for the member states to transpose the rules within the directive into their own national law. So basically, the legislation on mediation in civil and commercial matters within the EU is a directive, meaning as it's of 2008, it's already been transposed by all of the member states, except for, I believe, one that's opted out, which is Denmark, into national law. And it's designed to facilitate access to alternative dispute resolution mechanisms and promote amicable settlement of disputes while encouraging the use of mediation. It applies to cross-border disputes in civil, including family law and commercial matters, and it's applicable if at least one of the parties is domiciled in an EU member state, meaning it doesn't have to be an EU citizen. Even, of course, if it's a business, you could just as easily have a business from an Asian country that has a domicile in an EU member state that would also, that this directive would be applicable to under national law of the member states. Now, it's very weak in the regard that it promotes and encourages. It basically, it doesn't say that anyone has to resort to mediation. But what the EU, I believe, is trying to do is to cast a spotlight on ADR in general. So together with the directive from 2013 on ADR and online ADR from 2013, we're trying to, in Europe, we're trying to set a kind of framework to motivate people in disputes to use ADR rather than going to court. And I think this really goes back to this cultural point that I was referring to earlier. Now, some of the EU member states, as I mentioned, there's still national law that's applicable in each member state. Some of them go a lot harder on mediation. In fact, some of them impose mandatory mediation in certain cases. Now, Greece is an example that for certain matters, even if you apply to a court, the judge will say, no, you first mediate before I speak with you. So that, I think this type of imposed mandatory mediation is something that will hopefully help change the culture in Europe to prefer or think about ADR before going to court. We've also developed within the EU a European Code of Conduct, which you see on the top right there. This is not really law, but that it does set out principles which can guide individual mediators And can guide, I say, because they voluntarily commit to it. It's almost like best practices rather than rules, but it refers to principles such as ensuring that the mediator has competence to run the mediation, how they are appointed, the different types of fees that can be charged, and how their services also can be rendered. And it, of course, it addresses impartiality and confidentiality, the principles that I spoke about earlier. So now we're going from more general into more specific. As both Carolina and myself have mentioned, here at the EUIPO in Alicante, we've been offering various ADR services, including mediation, for some time now, let's say around a decade. And in our latest version of our founding regulation, which is called the European Union Trademark Regulation, we do actually have a provision that basically gives the office the possibility of offering to the parties that are in a dispute before the office the possibility to resolve the dispute through ADR. And it even goes further by allowing us to create a mediation center, which is actually what we're in the process of doing now. And I'm involved in that. And it's actually very exciting. So hopefully in future meetings, we'll be able to talk more about that. But for now, I can tell you that with a view towards going in following this trend of ADR and mediation, we do also have a number of boards of appeal presidium decisions, which can be found on the website of the ADR service. And they set out the rules and explain how all of the different ADR processes and services that are offered by the office work. So with that, I'm going to just quickly skim through the types of services that we offer in order to try to stay up to speed with the global trends and development in ADR. We offer mediation, which we've talked about. We offer conciliation, which is very close to mediation, except the conciliator can take a more active role by actually proposing potential solutions for the parties to consider. It's something that a mediator is not supposed to do. Expert determination, I've already presented briefly. It's basically when the parties invite an expert on the topic of their dispute to give an opinion, a determination, whether binding or not binding. That's decided by the parties. Then you have assisted negotiation and EDR. These are kind of sui generis services that the EUIPO has developed for small and medium enterprises. I won't go too deeply into that, but they're basically aimed at the office providing support to small and medium enterprises that find themselves in a dispute to identify potential mechanisms or processes that could help them resolve the dispute without there being a formal decision taken by the office. So basically, we go back to mediation, conciliation, and expert determination. And as we've talked about, we do also offer the potential for hybrids, which are part of the global trend in ADR and in IP.
Thank you very much, Goran. I hope you can hear me and I hope you can see my presentation all right. Ladies and gentlemen, thank you very much for having me back in this conference on mediation practice in IP. I understand that most of you present today are already experts in mediation as well as in IP. So if you attended the workshops last week, you might hear some repeated contents. However, I will try to provide information that in some way or another is useful for all participants. Now, firstly, in order to evaluate the suitability of mediation in IP matters, we must briefly recall the advantages of mediation in general, as they're inevitably linked to the suitability assessment. The first advantage is that with mediation, it is possible to focus on commercial interests and on business solutions. So obviously during a mediation, importance is given to legal issues, but primarily we focus on commercial interests and we look for business solutions. This is a very important difference between mediation and other traditional proceedings, as well as the other alternative dispute resolution tools that Goran was mentioning. The objective is to reconcile both parties' interests and to find a win-win solution. If the conflict would be resolved before a court, the court would not take into account personal and business issues or interests. A judge will mostly rule, as you know, over the facts presented and on the basis of the regulation and on the case law. With a mediation, it is possible to obtain a global solution to complex IP disputes. Goran already mentioned that it is frequently that we have to mediate a multinational conflict. And this would avoid obtaining different decisions from IP offices and diverging judgments from the courts, which obviously don't assist to solve the actual conflict between the parties. It would only prolong it. It is important to mention that mediation is in the hands of the parties. So what does it mean when we say that mediation is a flexible process? It means that for the parties, it is for them, to attempt finding, together with the mediator, a common ground that may lead to the settlement of the dispute. This is, for example, a clear difference to arbitration, by which the parties agree to submit the dispute to one or more arbitrators who make a binding decision on the dispute. Likewise, in the expert determination mentioned by Goran, the parties may agree that his or her opinion becomes binding for the parties. The expert decides on an issue on which the parties are unable to agree, a technical or a legal question that is part of the overall dispute. However, a mediator does not take any decisions. Likewise, in case of conciliation, which is not binding, the conciliator's proposals are discussed, negotiated, and fine-tuned with the parties. However, in the mediation, the mediator does not suggest any solution. It is for the parties to find the solution. The mediator merely helps them to find them for themselves. Obviously, we often get questions from the parties. What do you think? How do you see our chances of succeeding in this opposition division or whatever? But this is not what a mediator has to do. It was already said that mediation saves time and costs if the parties are involved in administrative or court proceedings. There are many direct and indirect costs that are implicit to litigation, such as providing evidence, conducting surveys, getting declarations. However, an effective settlement of a dispute by means of a mediation will considerably reduce these costs, especially if if the litigation involves different rights and different jurisdictions. And as to time savings, with the possibility of the endless appeals before different instances, an IP conflict may be protracted in time for years. A mediation may even lead to a situation in one day. Finally, confidentiality, that you will hear very often in these workshops, because it is one of the most important aspects of mediation. It concerns all parties involved, including the mediator. This was already mentioned by Goran, because contrary to the decisions of IP offices and of court judgments, these are of public domain, but mediations are not disclosed to the public. If the parties decide to go to mediation, it all remains confidential to the outside world, and during the same mediation, the mediator, unless expressly authorized to do so, cannot disclose the contents of what is discussed with each party. So, when is it appropriate to suggest mediation in the face of an IP conflict. So as we said in the previous workshop, mediation can offer a one-stop solution where different legal jurisdictions and geographical locations would otherwise involve a multiple cross-border litigation. So if there are identical or similar proceedings in other countries involving the same parties, mediation can help to solve a complex dispute in much shorter time. And mediation can also avoid the risk of divergent decisions in different jurisdictions. Because it might indeed happen that two different decisions are taken by IP courts in different countries regarding exactly the same dispute. And this would be a problem for both parties, and it is not a satisfactory situation for either of their business interests. It must also be taken into account that it is sometimes difficult to enforce a judgment in several countries. But however, agreements resulting from mediations are usually much more likely to be complied with by the parties. The same can be said when there are parallel disputes. Indeed, often there is a litigation which ranges over an entire portfolio of the IP portfolio of a company. IP mediation may also be appropriate to resolve conflicts involving different IP rights. Now, the parting point with us at EUIPO is always a trademark or design. However, it might be that the parties are also fighting over other IP rights, as for instance, a patent, a design, or a copyright. A further aspect that makes IP suitable for mediation is when there have been long-standing relations between the parties. Sometimes it emerges during the submissions of the parties that they have been previously involved in a business relationship that can be a license agreement, or that one party was the agent or representative of the other party. There may even be family relations between the parties. These cases seem to be especially suitable for mediation as they already know each other. Mediation may have many other positive consequences when it appears that the parties could cooperate on a business level, especially when they share the same commercial interests. An exploration into a settlement which contemplates a future commercial cooperation would lead to a highly satisfactory outcome, which maybe for some reason has not been previously approached by the parties or their lawyers. This might be because of linguistic reasons or simply because they never thought about it. And it may emerge from the exploration phase of the mediation. Also, when there have been long-standing conflicts in the past and the parties have already tried to negotiate, but without success, it is possible that a mediator can assist where perhaps lawyers have tried but did not succeed. Mediating an IP conflict also appears suitable, although it seems contradictory, when the parties' business activities are in different commercial areas. Perhaps because of, once again, language issues or a basic misunderstanding, the parties have not realized that they were actually never colliding on the marketplace. In mediation, this may be clarified. Finally, it may be in an IP dispute that both parties have strong and weak legal points. More than often, a case is not clear-cut. Each party may succeed on one point and fail on the other. For example, in a trademark dispute, one party may successfully oppose a trademark with respect of some of the goods, but the opposition may be rejected with respect of the other goods. It may also be that a party has a strong position in one country, but in another country it loses. This is a legal uncertainty that makes mediation a helpful tool to effectively resolve the dispute in these cases. If I may, I would very briefly go into some practical examples of IP conflicts which may be suitable for mediation. I know we are a bit over the time, so if I may go ahead, yes. I will very quickly give you some examples, just comparing practical cases of litigation versus mediation. So the first case would be a dispute between two EU-based companies relating to similar product labels. Okay, let's say for clothing. They are both registered as EU trademarks and national trademarks. There is an issue of their scope of protection, as they are weak marks because they have a common element which is descriptive. So what would the potential result of a litigation be? The parties may mutually destroy their trademarks by filing cross-invalidity and revocation actions. The dispute may last at both EU and before the national jurisdictions for many years and involve huge costs. What would be the potential result of mediation? The parties may agree to modify their trademarks. Maybe one of the parties receives a financial compensation in exchange. Both parties would maintain their trademark rights, and all EU and national proceedings would be closed. Clearly, this has resulted in a win-win situation that would not have been the result in a litigation or even in an arbitration or expert determination, where the issue would have been centered on legal issues. Let me briefly show you one more example. This would be a dispute between a beer producer who has filed an EU trademark with the intention of filing an international registration designating 20 countries. A restaurant, however, in Paris owns a reputed trademark in France for alcoholic beverages, which is highly similar to the trademark of the beer producer. What would the potential result of litigation be should these parties go to court? They might litigate for years at EUIPO. The beer producer may lose its EU trademark in an opposition confirmed by the boards of appeal and the general court. Consequently, he will have spent a lot of money and he will not have been able to file the international registration. And finally, the parties may have lost an opportunity of making business together. Because what would be the potential result of mediation? They might sign a coexistence agreement. They could both maintain their trademarks and agree to cooperate at a business level. So as you can see, there are many situations in IP that would be suitable for mediation.